Hey, it's Jen McCaskill. Today I'm talking to you about marital assets. Marital assets mean the assets that were acquired during the marriage. During the marriage in the land of divorce means the date that you were married until the date that somebody files for divorce. So the date of filing, between the date of marriage to the date of filing. Everything that you accumulate between those two bookend dates is quote unquote marital property, marital assets, and what that means is that they are subject to division between the two of you. They are on the table to be divided. Here's what's not included in a marital asset. Anything that either party receives via gift or inheritance, even if it was during the marriage, anything that you acquired before the marriage, anything that you acquire after the date of the filing of the complaint for divorce. The date of the filing of the complaint for divorce ends your marriage. It stops the clock on the accumulation of marital assets. So let's talk about this for a second. So if you have a retirement account, let's say you're working, you're not married, you're contributing to your 401k, and you have $20,000 in your 401k, then you get married. And then you accumulate another $10,000 during your marriage from the date, between the date that you get married and the date that somebody files for divorce. You accumulate another $10,000. You go to get divorced, that $20,000 is gonna stay yours. The $20,000 that you accumulated before you got married, and the only thing that's gonna get divided is the $10,000 that was accumulated while you were married. It's actually not that simple when it comes to retirement accounts because they're dictated by the stock market, so the value is always going up and down, but it's just an easy way to explain the concept, okay? Now, if one person receives money or property via gift or inheritance while you're married, the other spouse is not entitled to it, okay? But as long as it's not commingled. So let's say I'm married, my mom passes and leaves me $100,000 in inheritance. If I take that inheritance and I put it into an account that only holds that inheritance, that my husband's name is not on the account, and then I go to get divorced, my husband is not entitled to any piece of that $100,000, okay? Because I received it via gift or inheritance, even though it was during the marriage, it remains my sole and separate property, meaning it is not on the table to be divided between us. But if I take that $100,000 from my inheritance and I deposit it into a jointly titled bank account that I have with my husband, I deposit the $100,000 to the joint account, we use it, we live off of it, we buy a vacation home, whatever it is that we do with it, and then a couple years later I go to get divorced, I can't now claw back that $100,000 because I commingled it. I put it into an account, I took what was mine and I put it into a jointly titled account with my husband. Therefore, legally what I did was I gifted half of that inheritance to my husband by putting it into a jointly titled account. Another example that I hear all the time is somebody will come in and they'll say, well, I owned the house before we got married. You know, I owned the house for 10 years before we got married. But then after we got married, I had to refinance and I put my wife's name on it. Yeah, sucks for you. You don't now get more money from the house because you owned it 10 years before when you jointly titled it after you were married. Again, legally, the person took what was their premarital separate property and then gifted it to the marriage, essentially gifting their spouse half of the equity in that house. Now, there are some exceptions to that, like if it just happened within the last year or two before somebody files for divorce, then you have an equitable argument to make. It really depends upon the facts and circumstances. This is just very basic. Anything that you come into the marriage with remains yours as long as you didn't convert it to marital property. But like with the retirement account example that I did at the beginning, you still get a credit for your premarital contributions. So when you get married, save a copy of your 401k statement, because if you go to get divorced 15 years later and then you're like, humping like, shit, I should have saved a copy of that. I'm telling you right now, save a copy of it. Anything that you accumulate after somebody files for divorce is also considered separate property, because again, the date of the filing of the complaint for divorce ends the accumulation of marital property. So if, I file for divorce today, and then 6 months from now, I use the income that I have earned after the date of the complaint, and I use that income to buy a car, my spouse is not going to be entitled to half of the value of the car because I purchased it with post-complaint money and I purchased it post-complaint. So anything that you accumulate during the marriage is on the table to be divided between you unless it falls into one of the exceptions. And our job as divorce lawyers, one of the first things we do is we identify all of the assets and debts, we value all of the assets and debts, and then we argue about how we're going to divide them. How we value them depends upon the type of asset. If it's a house, we can have it appraised, or the house can get sold. If it's a 401k or a stock account, we just need an account statement as of the date of the filing of the complaint for divorce. With regard to a pension, you can pay somebody to value those, but those are really just an educated guess. And that's it. That's the basics of marital assets that everybody hates to divide. And as always, if you have any questions, call me.